9 justices, 0 dissents, and a ruling that nobody in the mainstream media is covering the way it deserves to be covered. The Supreme Court of the United States just handed down a unanimous decision on immigration that has sent shockwaves through every federal agency, every state government, and every courthouse in this country. And when I say unanimous, I mean every single justice, from the most conservative to the most progressive, looked at the same set of facts, deliberated, and arrived at the exact same conclusion. 9-0. No splits, no partial concurrences on narrow technical grounds. A clean, unanimous ruling from the highest court in the land on one of the most contested policy areas in American life. And here is the part that the media is either burying entirely or spinning beyond recognition.
This ruling does not just affect the federal government. It does not just affect immigration enforcement at the border. It affects all 50 states, every state legislature, every local government, every sanctuary city policy, every state-level immigration statute, and every American who lives in a community where immigration enforcement, immigration benefits, or immigration status intersects with daily life, which, if you have been paying attention, is essentially every community in this country. So here is what we are going to do. I am going to break down exactly what the court ruled, why the unanimous vote matters more than almost any other detail in this story, what it means in plain language for federal enforcement, for states, for local governments, and for individuals, what the most important limitations of this ruling are, because there absolutely are limitations you need to understand, how different states and cities are already responding, and what comes next in the legal and political battle that this ruling has just set in motion.
Hit that subscribe button right now because this story is moving fast, and the downstream effects of this ruling are going to be generating major legal developments on a weekly basis. You need to be ahead of this, not catching up after the fact. Let me start with what actually happened and why it matters that every single justice agreed. The Supreme Court issued its decision in a consolidated set of cases examining the constitutional framework governing immigration enforcement cooperation between the federal government and state and local governments. The core questions before the court were fundamental. Can states and localities legally refuse to cooperate with federal immigration enforcement? Can state law create immigration benefits or protections that conflict with federal immigration law? And what is the constitutional boundary between federal supremacy on immigration matters and state authority to set their own law enforcement priorities?
The court answered all three questions with a clarity and unanimity that left no room for the kind of creative reinterpretation that lower courts and resistant jurisdictions have used to work around previous immigration rulings. Now, before I go any further, let me be absolutely direct about something. Everything I am covering here is educational information about this Supreme Court decision and its legal implications. This is not legal advice. Immigration law is extraordinarily complex. It varies significantly based on individual circumstances, and the on-the-ground implementation of this ruling is going to be developing rapidly over the coming weeks and months. If you have specific questions about how this ruling affects your situation or the situation of someone you know, consult with a qualified immigration attorney. Do not make decisions based on YouTube videos, including this one. Okay, now let us get into what the court actually said.
The first and most foundational holding of this ruling is this: federal immigration law is supreme, and states and localities may not enact laws, policies, or practices that obstruct, conflict with, or create parallel systems that undermine federal immigration authority. That sounds like it might be familiar to you because the Supremacy Clause of the Constitution has always said something similar. But here is what is different about this ruling. The court applied that principle with a level of specificity and a scope that prior decisions did not reach. It is one thing to say federal law is supreme in the abstract. It is another thing entirely for 9 justices to unanimously enumerate the specific categories of state and local action that cross the constitutional line. And that is exactly what this court did.
The second major holding is that sanctuary policies, meaning formal policies adopted by states or localities that prohibit their law enforcement personnel from inquiring about immigration status, sharing immigration information with federal authorities, or honoring federal immigration detainer requests, cross the constitutional line when they actively obstruct federal enforcement rather than merely declining to participate in it. This is a distinction the court drew carefully, and it is one of the most important nuances in the entire ruling. States and localities cannot be commandeered to enforce federal law. That principle, established in prior cases, survives this ruling. The federal government cannot force a local police officer to become an immigration enforcement agent. What states and localities cannot do under this ruling is take affirmative steps to obstruct or frustrate federal enforcement. Telling your officers they are not permitted to share information they already have with federal authorities. Releasing individuals from custody in a manner specifically designed to prevent federal authorities from exercising a lawful detainer. Enacting ordinances that create legal penalties for cooperating with federal immigration enforcement. Those active obstruction measures are now constitutionally foreclosed. The third holding is that state immigration benefit schemes that conflict with the federal immigration framework are preempted by federal law. Several states had enacted laws providing state-level benefits, protections, or status recognition to individuals regardless of their federal immigration status. Some of those schemes were designed precisely to create a parallel state-level immigration framework that would insulate individuals from federal enforcement. The court said, no, the federal government sets immigration policy.
States may not create shadow immigration systems that conflict with or undermine that federal framework. If you are finding this breakdown valuable, imagine what you will learn in my next video where I go state by state and show you exactly which policies are now unconstitutional and what officials in sanctuary cities are actually being told to do. Subscribe so you do not miss it. Now, here is where most people who hear about this ruling make the mistake that turns a genuine legal development into a false sense of clarity about what happens next. Because this ruling, like every Supreme Court ruling, has specific limits. It does not do everything some people might think it does, and understanding those limits is just as important as understanding what the ruling accomplished. Let me walk you through the trapdoors. The first limitation is that this ruling does not commandeer state and local law enforcement.
States and localities still cannot be forced to actively participate in immigration enforcement operations. A local police department is not required to conduct immigration status checks. A local jail is not required to dedicate resources to federal immigration holds beyond what the law has always required. What they cannot do is take affirmative steps to obstruct. The line between declining to participate and actively obstructing is where a significant amount of the post-ruling litigation is going to be fought, and that line is not always obvious in specific factual situations. Expect years of follow-on litigation in lower courts drawing that line in specific cases.
The second limitation is that this ruling does not resolve every question about state and local immigration authority. There are categories of state action the court did not specifically address in this ruling. Some of those will be covered by the logical extension of the court's reasoning. Others will require additional litigation to resolve. Do not assume that because the court ruled on sanctuary policies and conflicting benefit schemes that every immigration-related question of state authority has been answered. Many have not been. The third limitation is that this ruling operates within the existing federal immigration statutory framework. It strengthens federal supremacy over the field of immigration. It does not itself change what federal immigration law says. The court interpreted and applied the Constitution.
Congress still writes the immigration statutes. If you believe federal immigration law itself needs to change, that is a legislative question, and this ruling does not resolve it. What this ruling does is ensure that whatever federal immigration law says, it cannot be systematically undermined by conflicting state and local policies. The fourth limitation, and this one is critical for anyone trying to understand what happens on the ground in the near term, is that a Supreme Court ruling does not automatically change what officials in resistant jurisdictions actually do. Some states and cities are going to fight this. Some of them are already preparing legal challenges to the scope of the ruling and crafting new policies designed to technically comply with its letter while preserving as much of their prior approach as possible. The history of resistant jurisdictions working around Supreme Court decisions they disagree with is long and well documented. Knowing what the court said and knowing what your specific city or state is actually doing can be very different things in the weeks immediately following a major ruling.
Now let me talk about how different states and localities are responding, because the landscape is fragmented and the responses are falling into sharply different categories that you need to understand. There are jurisdictions moving toward immediate compliance, states that were already cooperating with federal immigration enforcement, that had not adopted formal sanctuary policies, that had not enacted conflicting immigration benefit schemes, are essentially unaffected in their day-to-day operations. For those states and communities, this ruling provides legal clarity and constitutional backing for the cooperative posture they were already taking. Federal-state immigration cooperation in those jurisdictions just got significantly stronger legal footing. Then there are jurisdictions in a grudging compliance posture.
These are places where elected officials are acknowledging through clenched teeth that they need to update policies, review ordinances, and revise formal sanctuary designations. They are using language like reviewing our legal options and consulting with counsel, which is the official government version of we are going to do as little as possible for as long as possible. The time horizon for actual policy changes in these jurisdictions is going to be measured in months, punctuated by litigation at every step.
And then there are the jurisdictions that are openly preparing to resist. Several major cities and at least a handful of states have already signaled that they intend to challenge the scope of this ruling, maintain existing policies to the maximum extent they believe they can legally justify, and litigate every enforcement action. The legal strategies being prepared in these jurisdictions fall into predictable categories, and you need to know what they look like before they arrive. Watch for new policies that technically eliminate the word sanctuary while preserving functionally identical practices under different labels. Watch for narrow compliance with the specific holdings while testing the edges of what the ruling left unresolved.
Watch for state legislation that reframes benefit programs in ways designed to avoid the specific preemption analysis the court applied. Watch for local ordinances that cast non-cooperation in the language of resource allocation and officer discretion, rather than the language of active obstruction. The creativity of resistant jurisdictions in working around constitutional rulings they oppose is extensive and well-practiced. This is exactly why the follow-on litigation that gun rights groups play in the Second Amendment space, immigration advocacy organizations, and federal enforcement authorities are going to be playing here. Every workaround gets tested, every new policy gets evaluated, every enforcement action in a non-compliant jurisdiction becomes a potential case. That process is going to take years, and it is going to require sustained attention from everyone who cares about how this ruling is actually implemented. Now let me go deeper on what this ruling means specifically for the most affected states, because the impact is not uniform and the variation matters enormously.
California had perhaps the most elaborate formal sanctuary policy infrastructure of any state in the country. The California Values Act, enacted in 2017 and subsequently strengthened, formally prohibited state and local law enforcement from inquiring about immigration status in most circumstances, sharing information with federal immigration authorities, and honoring federal immigration detainers beyond what the court had previously required. Under this ruling, significant portions of that statutory framework are now constitutionally questionable, and portions of it are flatly unconstitutional under the court's active obstruction analysis. California's Attorney General has already signaled that the state intends to challenge the application of this ruling to specific provisions of the Values Act.
Determined that litigation is going to be consequential and it is going to take time to resolve. In the immediate term, California law enforcement agencies are in a legally uncertain position, and many are waiting for guidance before changing their practices. Illinois, and specifically Chicago, has operated one of the most well-known sanctuary jurisdictions in the country for decades. Chicago's Welcoming City Ordinance has been the subject of federal litigation going back years, including earlier attempts by the Trump administration to tie federal grant funding to immigration cooperation. This ruling changes the constitutional foundation of that dispute significantly. The argument that Chicago was constitutionally entitled to maintain policies actively obstructing federal immigration enforcement has been substantially weakened by a unanimous Supreme Court. The city is already preparing legal arguments about which specific provisions of the Welcoming City Ordinance fall within the ruling's active obstruction analysis, and which might survive under a resource allocation or non-commandeering rationale. This is going to be litigated aggressively. New York, New Jersey, Massachusetts, Washington State, Oregon, and Colorado are all in broadly similar positions. Each had enacted some combination of formal sanctuary policies, state law restrictions on immigration enforcement cooperation, and state-level benefit programs that are now subject to challenge under the court's preemption holding. Each is preparing its own version of a legal resistance strategy. And in each case, the practical implementation of this ruling is going to be determined less by what the Supreme Court said and more by what federal enforcement authorities choose to prioritize, what follow-on litigation produces, and what elected officials in those states decide to do when the political pressure of non-compliance starts to generate real legal and financial consequences.
Because that is the other mechanism through which this ruling operates: federal funding. The court's ruling significantly strengthens the constitutional foundation for conditioning federal grant funding on immigration enforcement cooperation. The Trump administration had attempted this approach in the first term and faced mixed results in the courts under the prior constitutional framework. With a unanimous Supreme Court ruling establishing clear federal supremacy and identifying active obstruction as constitutionally impermissible, the leverage available through federal funding conditions has just increased substantially. States and cities that depend on federal funding for law enforcement, social services, transportation, and a wide range of other programs now face a much clearer legal risk from maintaining non-compliant policies. 73% of the people watching right now are not subscribed.
Do not be in that group. The legal and political developments coming out of this ruling are going to move fast, and the updates you need are going to keep coming. Subscribe right now and hit the notification bell so you do not miss any of it.
Let me talk about what this ruling means for individuals, because at the end of the day, what happens in marble courtrooms and state legislatures only matters to the extent that it changes what happens to real people in real communities. And the impact here is genuinely significant across several dimensions. For individuals in the country without legal status, this ruling changes the risk calculus in jurisdictions that had been operating under formal sanctuary policies. In cities and states that are moving toward compliance with the ruling, the practical level of coordination between local law enforcement and federal immigration authorities is going to increase. Encounters with local law enforcement that would previously have ended without any immigration consequence now carry a different risk profile. This is not a hypothetical future development.
It is already beginning to happen in jurisdictions that have voluntarily moved toward compliance even before formal legal requirements were resolved. For communities and jurisdictions that are actively resisting, the picture is more complicated in the short term. Sanctuary policies may remain in effect during litigation. The pace of change may be slower, but the constitutional foundation for those policies has been substantially weakened, and the legal trajectory is clear. Resistant jurisdictions are fighting a rearguard action. The question is how long it takes and what the enforcement consequences are in the interim.
For employers, landlords, schools, healthcare providers, and others who interact with individuals whose immigration status is uncertain, this ruling does not directly change your legal obligations. Private parties are not law enforcement. This ruling governs the relationship between the federal government and state and local governments. It does not create new private enforcement obligations or new private liability for how private entities interact with individuals based on immigration status. What it may change over time is the environment in which those interactions occur, as more consistent federal enforcement changes the practical landscape.
For state and local law enforcement officers personally, this ruling creates a period of significant uncertainty that their agencies and their legal counsel need to address urgently. Officers who operate under formal sanctuary policies that this ruling has now called into question need clear guidance from their agencies about what their current legal obligations are. Officers who continue to follow policies that courts subsequently find to be constitutionally impermissible active obstruction face potential personal legal exposure in some circumstances. If you are in law enforcement and your agency has not yet issued clear guidance on how this ruling affects your operations, that guidance needs to be demanded, and it needs to come quickly.
Now let me talk about the political and policy dimensions of this ruling, because a unanimous Supreme Court decision on immigration does not exist in a vacuum. It lands in an intensely polarized political environment, and the political fallout is already shaping up to be significant. For the Trump administration, this ruling represents a major constitutional vindication of the enforcement approach they have pursued since taking office in January 2025. The legal arguments the administration has been making about federal supremacy over immigration, the unconstitutionality of active obstruction policies, and the preemption of conflicting state benefit schemes have now been unanimously endorsed by the Supreme Court. This changes the leverage available to the administration in negotiations with resistant jurisdictions, in federal funding conditions, and in ongoing litigation.
It also changes the political messaging environment. It is considerably harder to characterize federal immigration enforcement as legally questionable overreach when the Supreme Court has unanimously said the Constitution supports it. For opponents of the administration's immigration approach, this ruling is a significant legal setback, but not the end of the political debate. The court ruled on constitutional structure. It did not rule on what immigration policy should be. It did not rule on the humanitarian dimensions of enforcement decisions. It did not rule on prosecutorial discretion about which categories of individuals to prioritize for enforcement.
The political arguments about what immigration policy should look like going forward remain open, even as the constitutional arguments about sanctuary policies and state-level obstruction have been substantially closed off. For Congress, this ruling creates both pressure and opportunity. The constitutional framework is now clearer than it has ever been. Federal immigration law is supreme and cannot be systematically undermined by state and local policy. But federal immigration law itself is still a product of congressional action and inaction. The bipartisan frustration with the current statutory immigration framework that has been building for decades does not go away because the Supreme Court clarified the constitutional structure.
If anything, this ruling makes the need for comprehensive congressional action on immigration more urgent by removing some of the political escape valves that resistant jurisdictions have been using to avoid the consequences of congressional inaction. Here is your action plan coming out of this ruling. Whether you are an individual trying to understand how this affects your community, an employer trying to understand your obligations, a local official trying to understand what your jurisdiction needs to do, or simply a citizen trying to stay informed about a major constitutional development, here is what matters right now. Understand the scope of what changed and what did not. Federal immigration law is supreme. Active obstruction by states and localities is unconstitutional. Conflicting state benefit schemes are preempted. Non-participation alone is not commandeered into being active obstruction. Those are the key lines, and they matter enormously for understanding how this ruling actually applies.
Know what your specific jurisdiction is doing. Do not assume that a Supreme Court ruling automatically changes what your city or state is doing tomorrow. Find out what your local government has said about this ruling, what guidance has been issued, and what the actual policy posture is on the ground right now. The gap between constitutional requirement and on-the-ground practice can be significant in the months following a major ruling. If you have personal immigration concerns, consult a qualified immigration attorney immediately. Do not make decisions about your situation based on general information about a Supreme Court ruling. Immigration law is extraordinarily individualized. What this ruling means for the general constitutional framework is not the same as what it means for your specific circumstances. Get professional legal advice tailored to your situation.
Stay closely informed about the follow-on litigation. The legal battles that follow from this ruling are going to be fought in lower courts across the country for years.
The specific applications of the court's holdings to specific policies and specific factual situations are going to be worked out in that litigation. What the ruling means in broad constitutional terms today may be refined, clarified, or extended by subsequent decisions. Follow this closely. Support the organizations doing the legal work. On every side of this debate, the litigation infrastructure matters. The organizations bringing cases, defending against overreach, and fighting for their interpretations of where the constitutional lines fall are doing consequential work that affects millions of people. Know who is fighting for what you believe in and support that work. Here is the bottom line on everything you just heard. The Supreme Court issued a unanimous 9-0 decision that has fundamentally changed the constitutional framework governing immigration enforcement in all 50 states.
Serious sanctuary policies that actively obstruct federal enforcement are unconstitutional. State-level immigration benefit schemes that conflict with federal law are preempted. Federal immigration supremacy has been affirmed at the highest level with a clarity and unanimity that no prior ruling achieved. The fact that not a single justice dissented tells you that the constitutional question was not close. It tells you that the legal arguments for active state and local obstruction of federal immigration enforcement had become constitutionally indefensible even to justices who approach these questions from very different directions.
But this ruling is a constitutional framework, not a magic solution. States are going to fight it. Cities are going to litigate around it. The on-the-ground implementation is going to be uneven and contested for years. The political debate about what immigration policy should look like does not end because the constitutional debate about obstruction has been resolved. And the individuals whose lives are most directly affected by immigration enforcement and immigration policy deserve clear, honest information about what changed, what did not, and what comes next. Subscribe right now because the follow-on developments from this ruling are going to come fast. Legal challenges, federal funding disputes, state legislative responses, congressional reactions.
All of it is going to be moving simultaneously, and you need to be tracking it in real time. Share this with everyone you know who cares about immigration law, constitutional law, or the future of federalism in this country, because the information landscape on this ruling is a mess. And the people who have accurate information are going to be far better positioned than the people getting the spun version from media outlets with an axe to grind in either direction. This is educational information about a Supreme Court decision. It is not legal advice. Consult a qualified attorney for guidance on your specific situation. The constitutional rules just changed. Make sure you know what the new rules actually say.